Diddy is using like 8 other inmates' personal access codes to call everybody he wants.
Exactly.
It's like, add this person to the call, add this person. Yo, like he's running the jail. So these inmates, I completely believe, and by the way, this is how the government paints it. He's getting them paid directly through what they call these cash processing systems.
Yeah.
So, probably tells his people, yo, send her $1,000. Send his mom, send his girl, cool. And then the inmate in there with him is like, yo, we're gonna have your commissary filled. You're gonna move around like a king like me.
Hi everybody, it's me, AV to the 7th power. Welcome back to my channel where we talk about all things law, true crime, and a little bit of debauchery. Today we are getting up to speed on all things Diddy as he approaches his trial in May of 2025. On January 24th, we saw a new filing when it comes to an investigator that Diddy's team is not a fan of. Let's check it out. This looks like it is a letter to the judge, and it says, "Dear Judge, we write on behalf of Diddy to respond to declarations submitted by the government on January 17th, and in further support of Diddy's motion for a hearing suppression and other relief. The declarations show that ever since the government first tried to use Diddy's privilege note to continue his detention, it has presented a materially false narrative about how it got access to these sensitive, privileged materials containing his defense strategy and communications with his attorneys. Most significantly, the declarations reveal SDNY's supervisors directed BOP to search Diddy's unit because of its investigation and prosecution of Diddy. And they demonstrate the government has consistently monitored Diddy's legal calls. In other words, they confirm what Diddy has been arguing all along, but the search was conducted based upon a pretext, not for any legitimate reason, and that the investigators' surveillance before and during the search violated Diddy's constitutional rights and invaded the attorney-client privilege. Let's look at their argument. First, the declarations refute the government's repeated claims that the sweep was carried out to further legitimate interests and did not target Diddy. The declarations expose that after the sweep began, it was unclear whether Diddy's unit would be searched at all. Moreover, the search of that unit was carried out specifically at the direction of supervisors, including the supervisor for this case, because of their interest in obtaining evidence against Diddy. Second, the declarations show that the investigator became an agent of the prosecution team and worked to advance its case. He searched Diddy's bunk for evidence, not contraband. And it is clear his purpose was to gather evidence for the prosecution, not the police, any potential threats to security. Instead, it is notable that even though he has been surveilling Diddy's communications for months, to this day, BOP has not taken any actions to discipline Diddy for any purported violations of policies. Diddy has never received so much as a write-up in his 4 months in custody, despite the government's repeated complaints about his alleged obstruction and supposed violation of this policy. Third, the declarations confirm that the government was complicit in the investigators' continuous monitoring of Diddy's privileged communications. Investigator admits he listened to Diddy's calls, including calls with his lawyers, and that those recordings, including the ones with his attorneys, are being furnished by the U.S. Attorney's Office. Finally, the declarations raise additional questions that cannot fully and accurately be answered except through discovery and an evidentiary hearing. Just one example, despite reporting to prosecutors that he personally took photographs of Mr. Combs' notes. We have a redaction. The declarations are inconsistent with each other, omit key details, and rely extensively on hearsay, and are remarkably vague as to key points. The truth will only be fully revealed if the government's claims can be tested through cross-examination of witnesses who have actual knowledge of material facts. Otherwise, the court cannot fashion appropriate remedies without complete information that can only be discovered through such hearing. The government misrepresented facts and tried to conceal constitutional violations. Prosecutors directed the search, not BOP. The declarations contradict the government's prior representations concerning the reasons for the search and who directed it. The government previously claimed that the MDC sweep was planned by prison officials well in advance of Diddy's arrest. It was motivated solely by legitimate interests and did not target Diddy. It further claimed that no one in the case team supervised, conducted, or participated in the search, and that the search was organized or executed primarily by BOP's staff. These claims were essential to the government's opposition, which rested on the notion that prison officials are presumed to do their best to evaluate and monitor objectively the security needs of the institution, including and deciding whether a search is necessary. But these claims are false. The truth is that the search of Diddy's unit apparently was not even a part of BOP's original plan for the sweep, but it was SDNY supervisors, including the trial team's own unit chief, who ultimately directed the search. And the search was conducted not for legitimate institutional security reasons, but because they were interested in searching Diddy. Specifically, on the morning of the second day of the sweep, representatives from BOP and other federal agencies met to discuss a potential search of Diddy's unit. The agencies had not previously decided whether a search was necessary and inquired to the position of USAO SDNY regarding the potential search. Supervisor 2 and a unit chief who helped plan the sweep was present during the sweep and discussed with Supervisor 1 whether Diddy's unit should be searched. Supervisor 1 stated that it should be searched, in part because of what the prosecution team had learned regarding Diddy's conduct. Supervisor 1 conferred with senior leadership and relayed that Diddy's unit should be indeed be searched. And Supervisor 2 further relayed to BOP leading the search. No SDNY personnel directed how the search of the unit would be conducted. She didn't deny that the supervisors directed the search itself. That flatly contradicts the government's prior representations. Next, Investigator 1 was searching for evidence, not contraband. The declarations also contradict the government's prior narrative concerning its relationship with Investigator 1 and his motivations. The government previously claimed that the case team's investigation and the BOP investigation have operated independently. At 16, that Investigator 1 was merely searching for contraband, not evidence, during the sweep. The declarations show that both of these claims were false. In fact, the government and Investigator 1 worked in a coordinated fashion for at least 2 weeks leading up to the search, and the trial team encouraged Investigator 1 to monitor Diddy's communications. BOP personnel contacted Supervisor 1 to inform her that Investigator 1 was monitoring Diddy's communications and found relevant evidence. That date is insignificant because it was 10 days after Diddy filed his widely publicized notice of appeal concerning the detention order, and the same day the court invited the defense to make a renewed bail application. Notably, investigators on this case have been present for all court appearances in the matter, including that October 10th conference. Investigator 1 clearly became an agent of the prosecution team. He collected, screened, and shared evidence while collaborating with the trial team prosecutor, and the fruits of his investigation were ultimately used by the government to try to detain Diddy. He made a point of alerting them to Diddy's plans to discredit possible witnesses and find dirt on people. In other words, core defense strategy protected by the Sixth Amendment, unrelated to any legitimate concerns. And the prosecutors have used information Investigator 1 illegally obtained in various ways. We cannot know the full extent of the improper uses of the fruits of the search without a hearing. And despite the government's claims of Investigator 1 was monitoring Diddy because of purported violations to BOP policy, Diddy has not once been disciplined or even asked by MDC to stop engaging in the cited conduct. If Investigator 1 surveillance was generally undertaken solely for purposes, why does it seem that the fruits of the work has only been used by the prosecutors and not by the BOP? Clearly, Investigator 1 searched Diddy's notes during the sweep to find evidence for the prosecutors. He was not searching for contraband, as the government previously represented to the court. Moreover, the government did not proceed in good faith and took no steps to avoid violating Diddy's rights. The declarations confirm that the government has consistently monitored Diddy's privileged communications with his attorneys. In opposition to the defense motion, the government claimed it made a good faith effort to avoid coming into contact with privileged material, contrary to facts and logic to suggest Investigator 1 was the informant in the defense camp. But it turns out Investigator 1 has been spying on the defense team all along. Investigator 1 has thus repeatedly informed the trial team that he was eavesdropping on privileged communications, but the trial team never instructed him to stop. This is outrageous. Worse, the trial team endorsed this conduct by requesting communications at issue. Accordingly, the government has obtained and produced to the defense over 30 of the defense's own calls with Diddy. That is an egregious breach of Diddy's rights, and the judge should immediately order the government and the BOP to cease any such spying on the defense camp. These declarations show that further discovery and a hearing are required. The Slavic declaration is largely based on unsworn hearsay, much of which is vague and raises more questions than it answers. For example, the discussion between the unidentified BOP personnel and Supervisor 1 on October 10th lacks any detail. Important questions remain. Who are the BOP personnel? What was said? Why was supervisor number 1 contacted? Seemingly out of the blue by BOP. And how did BOP know who to contact? Based on this chain of events, it is likely that BOP had standing orders from Supervisor 1 or somebody from the Southern District of New York personnel to monitor Diddy and report on his conduct. This is a misspelling. It says where, it should say where were there other communications leading up to this call? Slavic also fails to share what she personally discussed with Investigator 1. She merely states, I spoke with Investigator 1 on several other occasions in October and November. But again, glaring questions remain as to what was said and what expectations arose from those communications. The declaration further references, without describing multiple conversations and meetings involving BOP personnel, certain SDNY personnel, and other government officials. It references multiple other conversations and meetings between Supervisor 2 and 1 during which the supervisor specifically discussed Diddy. There were also references to conversations between Supervisor 1 and SDNY senior leadership. The court's consideration of Diddy's motion should not be based on such rank. Nondescript hearsay, further discovery, and testimony from these individuals is required. Investigator 1's declaration lacks important details. The prosecution team also includes Supervisor 1, Supervisor 2, and SDNY senior leadership. The government should produce the emails and other evidence. Instead of sharing the full story, the government has cherry-picked a few facts and submitted declarations that undermine the ability of its previous submissions, omit key facts, and raise numerous important questions about what really happened. A full hearing in which Diddy's lawyers are afforded the opportunity to cross-examine the government actors with knowledge of the facts relevant to the search is the only way to find the true facts and understand the full picture, so that the court can assess how best to remedy this grave violation of Diddy's constitutional rights. Diddy therefore respectfully requests that the court order the government to produce the additional discovery described in this letter, as well as whatever communication already shared with the court in camera, and hold a hearing. So there you have it, guys. There was an investigator that had been really monitoring Diddy's movements while he has been in custody. Diddy's team is screaming on the mountaintops because there are certain scenarios where information is protected by privilege, attorney-client privilege, especially when you are preparing for trial with a defendant that is in custody. He's always under constant supervision, but his phone calls, any notes, and things related to trial preparation can be considered protected. Let me know what you think in the comment section below. See you in the next one. Stay safe out there. Bye.